Welcome to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. This course is about a paradox. How do you share your secrets while keeping them secret? That question sits at the center of billions of dollars in litigation every year. Companies need to disclose secrets to employees, vendors, and partners to do business. But every disclosure creates risk. Trade secret law is the legal framework that makes disciplined sharing possible. In this first lecture, we'll explore why trade secrets matter, what makes them different from other forms of intellectual property, and how the law evolved from scattered common law rules into a coherent statutory framework. By the end, you'll understand why I call trade secrets the dark matter of intellectual property, invisible but everywhere. Let's start with a story. In 1886, John Pemberton created a syrup for a new soft drink in Atlanta, Georgia. The formula has never been patented. It's never been published. For nearly 140 years, the Coca-Cola formula has remained one of the world's most famous trade secrets. Why didn't Pemberton patent it? Under the patent law in effect in 1886, a patent would have given Coca-Cola 17 years of exclusive rights. After that, the formula would have entered the public domain by 1903. Anyone could have legally copied it. Pepsi wouldn't be invented until 1893, and it wouldn't become a major competitor for decades. But by 1903, anyone could have made an identical product using Coca-Cola's now public formula. Now, you might be thinking, wait, aren't patents 20 years? Yes, today they are. But that's a relatively recent change. From 1861 through 1994, U.S. patents lasted 17 years from the date of issuance. In 1995, as part of harmonizing U.S. law with international treaties, Congress changed the term to 20 years from the date of filing. The strategic point remains the same. By keeping the formula secret instead of patenting it, Coca-Cola has maintained its competitive advantage for more than a century, far longer than any patent could have provided. But here's the paradox I mentioned. Coca-Cola doesn't keep the formula locked in a vault that nobody can access. The company manufactures over 1.9 billion servings of Coke products every single day. That means bottlers, suppliers, quality control specialists, and manufacturing partners need access to at least parts of the process. The company has to share the secret to make the product, but in a way that doesn't destroy the secrecy. That's what trade secret law enables. Disciplined sharing. It creates legal duties and remedies that allow companies to disclose information selectively without losing all protection. The Coca-Cola example might seem exceptional, but trade secrets are everywhere. WD-40's formula has been a trade secret since 1953. KFC's blend of 11 herbs and spices remains secret, though former employees have claimed it's simpler than the company lets on. Google's search algorithm, the precise way it ranks web pages, has never been fully disclosed. Customer lists at professional service firms, manufacturing processes that give companies a cost advantage, pricing strategies that competitors would love to know, failed drug trials that tell pharmaceutical companies which compounds not to pursue, saving them millions in R&D costs. One study estimated that trade secrets represent more economic value than all patents and copyrights combined. Yet most business law students graduate without ever studying them systematically. Why? Because trade secrets are, by definition, secret. There's no public registry like the Patent Office or Copyright Office. No publication requirement. When a company successfully protects a trade secret, the public never learns about it. We only see trade secrets when protection fails, when someone steals them, when an employee leaves and takes them to a competitor, when a business relationship breaks down, and litigation forces disclosure. I sometimes call trade secrets the dark matter of intellectual property. In astrophysics, dark matter is invisible but makes up most of the universe's mass. Scientists know it's there because they can observe its gravitational effects on visible matter. Trade secrets work the same way. We can't see them directly, but we see their effects everywhere. And, like dark matter, there's strong evidence that trade secrets make up the bulk of intellectual property. In terms of total value, all the trade secrets are probably worth more than all the patents, copyrights, and trademarks combined. We see the effect of trade secrets and competitive advantages that persist for decades without apparent explanation. We even get a glimpse of the secrets themselves in litigation over customer lists and manufacturing processes. We see shadows of trade secrets cast over employment agreements that restrict what departing employees can do. We see a projection of trade secrets onto the non-disclosure agreements that govern every significant business relationship: investor due diligence, supplier negotiations, joint ventures, M&A transactions. So while we don't see trade secrets themselves all that often, we know they are very real. Understanding how to protect trade secrets is essential for anyone who will advise companies. Whether you're in-house counsel, outside litigation counsel, or a business executive making strategic decisions about innovation, you need to know when to patent, when to publish, and when to keep information confidential. Now that we understand why this matters, let's turn to the legal framework that makes trade secret protection possible. Trade secret law began as common law, judge-made rules that evolved case by case over centuries. The earliest cases involved employees who left to work for competitors and used confidential information they learned on the job. Courts recognized that this was wrongful, but they disagreed about why. Some courts treated it as breach of contract. If you signed an agreement promising confidentiality, using that information violated the contract. But what if there was no written agreement? Some courts said it didn't matter. There was an implied duty of loyalty that survived the employment relationship. Other courts treated it as a kind of property theft. If the employer owned the information, taking it was like stealing physical property. But this analogy was always awkward. Information isn't like a chair or a car. If I take your chair, you no longer have it. If I learn your secret, we both have it. The information hasn't disappeared. It's just no longer exclusive. Still, other courts focused on the wrongfulness of the acquisition. It wasn't that the information was property exactly, but that acquiring it through improper means, breach of confidence, espionage, trickery, was a tort. The remedy wasn't about protecting ownership, it was about punishing misconduct. These different theories led to inconsistent results. What qualified as a trade secret in California might not qualify in New York. What remedies were available, injunctions versus damages, varied dramatically. Choice of law became a strategic weapon in litigation. Forum shopping was rampant. In 1939, the Restatement of Torts tried to bring order to this chaos. It defined trade secrets and listed factors courts should consider. That helped, but it didn't create uniformity because the restatement wasn't law. It was just an influential summary of what courts were doing. Real uniformity came in 1979 when the National Conference of Commissioners on Uniform State Laws promulgated the Uniform Trade Secrets Act, the UTSA. The goal was to create a model statute that states could adopt, replacing the patchwork of common law rules with consistent statutory standards. Most states adopted the UTSA, though many made modifications. Some added definitions. Some changed remedies. Some created exceptions for specific industries. So even the Uniform Act wasn't perfectly uniform, but it was a vast improvement over the free-for-all of common law. Then, in 2016, Congress did something surprising. It passed the Defend Trade Secrets Act, the DTSA, creating a federal cause of action for trade secret misappropriation for the first time. Before 2016, trade secret law was exclusively a matter of state law. If you wanted to sue for misappropriation, you filed in state court under your state's version of the UTSA or under common law. The DTSA changed that. Now plaintiffs can file in federal court under federal law. They don't have to rely on state law at all, though they usually plead both federal and state claims in the same lawsuit. Why did Congress create federal jurisdiction? A few reasons. First, trade secret theft increasingly involves interstate and international conduct. An employee in California downloads files, moves to Texas, and starts working for a competitor headquartered in Delaware. Which state's law applies? Federal law solves that problem. Second, trade secrets were the only major category of intellectual property without federal protection. Patents, copyrights, and trademarks were federal. Trade secrets were the odd one out. The DTSA brought them into the fold. The good news is that the UTSA and DTSA are substantially similar. Both are built on the same foundation, the three-element test for what qualifies as a trade secret. Both prohibit misappropriation through improper means or breach of confidence. Both offer similar remedies, injunctions, damages, and in extreme cases, punitive damages and attorney's fees. For most purposes, you can think of them as parallel systems. Plaintiffs today typically sue under both the federal DTSA and their state's UTSA. Courts apply them side by side. The differences matter in some cases, most notably around remedies like ex parte seizures and statutes of limitations. But for our purposes, the core concepts are the same. Let's zoom in on that core concept, the three-element test. For information to qualify as a trade secret under the UTSA or DTSA, three elements must be satisfied. First, it must be information. Second, it must derive independent economic value from not being generally known or readily ascertainable. Third, the owner must make reasonable efforts to maintain its secrecy. Let's break those down. First, it must be information. That's broader than it sounds. It's not limited to formulas or blueprints. Information can be a formula, like the Coca-Cola recipe. It can be a process, a sequence of manufacturing steps. It can be a customer list, showing who buys what and when. It can be a pricing strategy. It can be source code for software. It can even be negative know-how, information about what doesn't work. Negative know-how is a fascinating category. Imagine you spend 5 years testing 200 different chemical compounds trying to develop a new adhesive. 199 of them fail. The 200th works. You might think only the working formula is valuable, but the knowledge that the other 199 don't work is also valuable. A competitor could save years of trial and error by knowing which paths are dead ends. Courts have repeatedly held that negative know-how can qualify as a trade secret. The information can be technical or commercial. It can be a single fact or a complex combination of facts. What matters is that it's information, something that can be known, recorded, communicated. Second, the information must derive independent economic value from not being generally known or readily ascertainable by others who can obtain economic value from its disclosure or use. Let's unpack that mouthful. The key word is independent. The value has to come from the secrecy itself, not from some other source. If everyone in your industry already knows how to do something, it doesn't matter that you also know it. There's no competitive advantage. If your competitors could easily figure it out through lawful means, like reverse engineering, publicly available sources, or independent research, then it's not really secret. The economic value doesn't have to be actual. Potential value is enough. You don't need to prove you've made $1 million from the secret. You just need to show that it gives you an advantage in the marketplace or that competitors would benefit from knowing it. The standard is not generally known or readily ascertainable. That "or" is important. Information can be secret even if it's theoretically discoverable, as long as discovering it would require significant time, effort, or expense. The fact that a competitor could eventually reverse engineer your product doesn't mean it's not a trade secret today. As long as reverse engineering takes time and costs money, the information retains economic value from secrecy. Third, the owner must make reasonable efforts to maintain its secrecy. This is the element that gives companies the most trouble in practice. Notice the standard is reasonable efforts, not perfect efforts. You don't need Fort Knox level security. You don't need to encrypt every email and lock every document in a safe. The law recognizes that absolute secrecy is impossible if you want to actually use the information in business. But you do need to make efforts that are proportionate to the value of the information and the circumstances of your business. What's reasonable for a 10-person startup is different from what's reasonable for a Fortune 500 company. What's reasonable for a manufacturing process that only 3 employees ever see is different from what's reasonable for a customer list that your entire sales force uses daily. Courts look at a range of factors. Do you have written confidentiality agreements? Do you mark documents as confidential? Do you limit access on a need-to-know basis? Do you have physical security measures like locks and badge access? Do you have digital security measures like passwords and encryption? Do you train employees on confidentiality obligations? No single factor is determinative. It's a totality of the circumstances analysis. But here's the key insight. The reasonable efforts element is where most trade secret cases are won or lost. If you can't show that you treated the information as secret, courts won't treat it as secret either. Let's recap where we are. Trade secrets are everywhere. They represent more economic value than patents and copyrights combined, yet they remain largely invisible because they're protected through secrecy rather than publication. The law evolved from inconsistent common law rules to a relatively uniform statutory framework. Most states have adopted some version of the Uniform Trade Secrets Act. Since 2016, there's also been a federal cause of action under the Defend Trade Secrets Act. To qualify for protection, information must satisfy three elements. It must be information, it must derive independent economic value from secrecy, and the owner must make reasonable efforts to keep it secret. Those three elements are the gatekeeper. If anyone is missing, you don't have a trade secret. That means you can't sue for misappropriation. You can't stop someone from using or disclosing the information. You can't recover damages. In our next lecture, we'll dive deeper into the strategic choice between patents and trade secrets. We'll look at a landmark Supreme Court case that explains why companies are free to choose secrecy even for patentable inventions. We'll explore when patents make sense and when trade secrets make sense. And we'll talk about the risks that come with each approach. For now, I want you to think about this. If you were advising Coca-Cola in 1886, would you have recommended patenting the formula or keeping it secret? What factors would you weigh? What questions would you ask? That's not a hypothetical exercise. That's the kind of strategic advice you'll be giving clients throughout your career. Understanding trade secret law isn't just about knowing the rules. It's about helping clients make choices that align legal protection with business strategy. Thanks for listening. I'll see you in the next lecture.